The Constitution or delayed RMDs. Hi, it's financial planner Sean Mullaney. Let's discuss. So we're in a very interesting situation right now. Recall that Secure 2.0 delayed RMDs for most Americans, right? For many Americans, it was to age 73. For many Americans, it was to age 75. So people love that, right? Like, hey, if we could push these RMDs into the future, that makes us all happy. But there's just a bit of a problem with that. It has to do with Secure 2.0 and the omnibus bill that was part of. Recall that was passed back in 2022, December of 2022, in fact. And they did it at a time Congress was using proxies. It relates to the COVID procedures and whatnot. And so when they passed the omnibus bill, which included Secure 2.0, they established the necessary quorum in the House of Representatives to enact legislation through proxies. And in fact, it's not even really that disputed. There were fewer than half plus one of the House of Representatives actually present when the omnibus bill passed. Well, interestingly enough, the state of Texas picked that fact up, and they sued the federal government over certain omnibus bill provisions as they apply to the state of Texas. And sure enough, they won. A federal district court judge in Lubbock, Texas, in February of 2024, issued a 120-page opinion going through the case and saying, hey, look, there's this quorum clause in the United States Constitution, and under the quorum clause, at that moment in time, the House of Representatives impermissibly used proxies to establish a quorum. They didn't have a quorum. The omnibus bill, as it applied to the state of Texas with respect to certain provisions, is invalid. Well, okay, that's fine and good. By itself, it has nothing to do with Secure 2.0, but it creates this huge problem for Secure 2.0. Because if the omnibus bill was not validly passed, then Secure 2.0 is not the law of the land. And anyone else can pick up that case down in Texas, go to another federal judge and say, hey, this issue was litigated and there's a really well-researched and reasoned opinion. Why don't you invalidate Secure 2.0 as applied to us? And now we have a new administration, and they're going to have to make a decision as regarding Secure 2.0. Do they enforce it, right? They're going to have a new Office of Tax Policy, a new Assistant Secretary for Tax Policy in the Treasury Department, and he or she's going to have to make a decision. That decision is, do we honor Secure 2.0? And I would argue that the judge down in Texas did a really good job and came up with the right conclusion that the omnibus was not passed in a constitutionally qualified manner. And so that creates an issue for the new administration, the Trump administration, right? Do they enforce a law that frankly doesn't appear to be the law of the land because it was not passed in a constitutionally qualified manner? And it creates risk for the new administration. So what do I mean by that? Well, there's a provision in Secure 2.0 that a lot of people are not going to like. It's a provision that says you can't deduct catch-up contributions to a 401k or similar plan if your income last year was too high. And it's a relatively modest bar they set in Secure 2.0. Well, that's going to give plenty of employees, employers, and plans incentive to go to federal court and say, hey, judge, Secure 2.0 isn't invalid. Let us deduct our catch-up contributions to 401k plans. And oh, by the way, another judge down in Texas looked at all this stuff and we're adopting his arguments, and this wasn't validly passed. So the Trump administration now has this risk, right? Would they commit Department of Justice attorneys in the Trump Department of Justice to argue for a bill that was passed by mostly Democrats and signed by a Democrat president, right? Would they use Trump DOJ resources to defend a bill they had nothing to do with? That seems very odd. So my hope is that the new folks at Treasury say, look, there's a problem here, and we have to honor the Constitution. And the way we do that is by having a notice, right? Issue a notice from the IRS and Treasury saying, there's a constitutional problem here. We are not going to uphold Secure 2.0, and we're going to implement provisions to hold folks harmless, right? This isn't about punishing people who used Secure 2.0 in the last 2 years, because look, it appeared to be the law of the land. And those folks were acting in good faith under what's sometimes referred to as the color of law. Folks really thought Secure 2.0 was the law of the land. But based on the reasoning from this court case in Texas, and I'm going to link to that opinion in the description below, and I encourage you to be the judge and jury in your own mind, right? Don't take Sean Mullaney's word for it. Look at that court case, see what you think. But a law that was not enacted in a constitutionally qualified manner, even if it delays RMDs like we all like, should not be the law of the land. What do you think? Let me know in the comments below. Thanks so much for watching. Hope you enjoyed this video. If you did, please mash that like button and subscribe to my channel. I'll see you next time.